Hey Jeff, I have a phone number for you to call in. They will 561-578.
Do you want this one? This one?
4810.
Or you can put my phone next to it.
I asked.
Or you can put the paperwork right here.
Okay, we use that little handheld plus the video. Right.
You didn't stick around last night? Sure.
Actually.
You'd be in the same mood we were in.
We're recording.
That doesn't sound good. Wait a minute.
I don't mean to be laughing, but
I want to
didn't know.
redo. I'll wait till tomorrow. Can we reconvene?
No,
We're recording. We're recording.
Okay.
Are we on record? Okay, because we haven't got the turn call. You guys go ahead, I'll answer.
Oh, hang on a minute here. So,
How do you answer?
Oh, hit the white button on the left.
Yeah.
Yeah, upper left. Yeah.
Hello?
Hi, Attorney Jeff Brown, calling in with my thanks for your allowing me to call in.
Okay, Jeff, this is Mike Cirillo. I just was answering the phone.
No, I might look like a good receptionist.
Yeah, there you go. Anyway, I'm going to step away and then go forward.
okay, everyone is here. Are you able to hear me, Mr. Brown?
Yes, I can, and let me thank you for allowing me to attend by telephone, and I can hear fine.
Okay. The other thing is we do have it, as you would imagine, we are recording, so there's a recorder next to the speaker for the speakerphone, so we're hoping to be able to pick up your voice as well. Just to sort of get us back on track here, I guess first let me call the meeting to order. Today is Wednesday, January 16. It's a little before 10. Everyone is present, I believe, for the hearing we're going to have on case 2012-277, so there's an agreement that we can start a few minutes early. So let me first start by swearing in any witnesses, and we'll just pick up with the case. Are you going to be testifying?
Well, we're going to have some representations, but if you want, you can swear in.
Okay, yeah, let's get everybody sworn in who may testify. Do you swear the testimony you'll give to be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
And I guess we have nothing on the fine or lien certification. Back to case number 2012-277. Now, my memory is that we, of course, didn't finish. We went through, I guess, did the town finish its case? I guess not.
Mr. Donnie, Mike Cirillo is town attorney. Yes, what happened at the last one, you may recall, is we had a witness who wanted to have testified. So the town went through its case to regarding the alleged violations, and then it was continued. The reason it's been continued, and Mr. Brown can step in and talk about, I don't mean to misspeak on anything, I believe we're on the same page, is that the petitioner and the respondent there had stated they were going to file some applications with the town to have it reviewed in a way to resolve the matter and bring conformity to the land and the property, at least from our perspective. So at the last meeting, it was agreed we would not seek an order, but we needed to put our case on because we had witnesses that were present. We had intended to move forward today to conclude the hearing, but yesterday the applicant did provide, late yesterday, a letter which we do not object to putting into the record from a retained land planner to what I would say finally get the ball rolling on this matter. Given the lateness of the receipt of this letter and the complexities of this, we had indicated that we expect they will make a request this morning to continue the case. They haven't done that yet. And so that's where we're at.
Okay.
Your Honor, this is Jeff Brown. Michael is active, and we are requesting a continuance. We would ask the court to accept the letter from the land planner into evidence as part of our request, and that's the basis for our request to continue it. We are not attempting to delay anything. We are working with the city and will continue to do so. The length of our requested continuance will be 60 days. I was considering only asking for 30 until I learned that the land planner would prefer 60, and that is the reason for what I consider to be a lengthy request. But so as to not come back and either come up there in 30 days and take up your time and the city's, I would suggest that we work diligently during that 60 days. Maybe we can do it in advance of 60, but I hate to be running around like a chicken with our head cut off, excuse the analogy, in 25 to 30 days, and that is the reason for that request. The basis for any request is that it is the land planner who has work to do and needs to get things to and from the city and move forward. And I will personally advise him of whatever Your Honor would consider to be a reasonable request for continuance, and let him know that this is not the first time we have sought a continuance, and that the city needs to move forward with something very concrete, and the process isn't a manner of delay, but really a manner of progress in getting this thing where we need to get it. And that is the reason for my request of 60 days.
Okay. Is there any objection to 60 days?
Mr. Donny, the city would not object to 30. We do not believe that 60 days would be appropriate. And the reason that I would say that is this, that the last hearing we had was, what, 60 days ago?
It was October.
Yeah, October? Okay, so that was 90 days. And although there's been some communications, this is really the gist of what the town has received from this respondent since then, and it came yesterday. We need to move this forward, and what we would expect to be able to happen is to continue this matter. We think that getting an application filed with the town, it may not be finally complete, but an application filed with the town that has a complete application, and that there's documents or information responsive to each element in that application filed with the town before the next hearing, then we could consider moving this again back, because we need to have progress on this. I understand the concerns about the short turnaround, but again, we've already had 90 days to move this, and we would expect to see some real progress in the next 25 to 30 days. And I just put that on the record. It would be our position, just so the respondent understands too, is that we do not want to be dealing with something like we did yesterday and getting something the day before a hearing. If we don't agree to a continuance with them on the Friday before the next hearing, we're not going to agree to any further continuances. So they need to do what they need to do and get the information to us, so we'll agree to a request or on the Friday before the next hearing. At least that's what our position is. Whatever you order, but we want to make it clear that we expect to see something complete filed with the town in the very near future.
Okay.
Your Honor, I never have any objection to anything Michael says.
Okay. Let me take a moment to read the letter here. I haven't had a chance. I will admit it into evidence. I think we were through 7 exhibits at the last time we met. So we'll just keep numbering them consecutively. We'll call it exhibit number 8 and admit it into evidence. And let me take a moment to read it. Does this, Mr. Kilday uses the term land use amendment. Is this actually going to take land use amendment?
Yes. To do what they want to do, yes. I mean, because obviously, there's two ways, there's multiple ways to remedy it. What the applicant, what the respondent would like to do is bring the land use in conformity with what's going on the property, and that will take a land use amendment. And that ultimately, there's no guarantee on that, because, but we're willing to work to allow them the opportunity to go that route, but we need to see some progress.
Right. But that would be certainly a fairly lengthy process. How long do you think it would take, assuming you get a prompt application?
Well, it would be small scale, so it would be a shorter time period, but for the fact that the town is in a moratorium, the soonest we could actually take action on it, through planning and zoning, or even, and the council would be, April, but it would take that time, even if, on that timeline, there's going to be a review by our planner, there's going to be comments that have to go back and forth. This would be a DRC matter, right? So,
No, it wouldn't be DRC.
Oh, it's not the DRC. So there's going to be, I mean, no slight intended to Mr. Kildare, but hardly ever do you get the application perfect the first time. We just want a complete application that we would expect to see any developer or landowner file, so that we can start that back and forth and be in a position to move this as soon as the moratorium ends. And in order for that to happen, we need the application in the next, before the next hearing.
May I speak, Your Honor?
You, 1 second. When does the moratorium end?
Right now, it's scheduled to end March 31st.
Okay.
Well, yeah, I mean, one more thing, just as part of the application too, there's a cost recovery, and that's gonna have to be addressed, but that doesn't have to be addressed this morning.
Cost recovery for
There's
the
whenever an application is filed with the town does an estimate of what the work is going to be for the planner, for the attorney, and for and advertising and whatnot, and that's gonna have to be part of the application too. I don't have any idea what that number is, I'm just putting it on the record. And that's standard operating procedure. That's nothing because we're in code. Yeah, it's not because we're in a code situation, it's a standard operating procedure.
Okay, yes, sir.
We have a lot of money tied up in several different buildings on this 15.5 acre parcel, Your Honor. And what our land planner, Terry Kildare, is trying to do is, he's ordered surveyors to come out, check setbacks and check different things, so he can coordinate sectioning off 10 acres of the property as commercial and keeping 5.5 acres as agricultural use, due to the fact that our home is there, due to the fact that our stable's there, and there's a lot of money tied up in structures. That's kind of why he needed a little more time to allow that. And then we need to find out, like today's the first day that I'm finding out that the moratorium will be lifted in April. I had no idea up until Mike just said that. And then we need to find out basically what a fee schedule is, so we can allow and budget different things to get that accomplished. So, just so you understand that, there's several buildings on the property, and it makes it for a complex situation.
Okay. I guess that if I'm gauging the situation, the town wants to see this move along.
Yes.
I mean, either have a hearing and a ruling, or the land use process move. And however, it doesn't seem that, maybe other than an application, there's going to be a whole lot accomplished prior to 30 days. Would that be a fair statement?
Well, yes and no. I mean, yeah, I think realistically, the best we can expect to be in 30 days is an application. But that's why we only want to continue this case to the next hearing, because if we don't get an application, we don't want to have this case continue anymore.
Okay.
I mean, again, I said there were multiple ways of bringing it into compliance, and we've been working with them on their preferred option. But if they're not going to be diligent pursuing the option that they've indicated they want to pursue, we want to conclude the hearing. So that's why, requested at the very least, we would be here on a status conference. At the very most, we'd be here to conclude the hearing. The next, that's what we're requesting.
What date would the February hearings be? Everybody have a calendar?
Third Wednesday.
All these fancy phones, somebody has.
I'm good, man. The 20th.
20th.
Okay.
So that's 35 days. And that would mean that we want to be in a position to agree on anything to continue this by the 15th. So they have like 30 days to get to the point where the town would agree to a continuance.
Are there going to be other cases in February?
Yes, sir.
Pardon me?
Yes, sir.
Okay, so we'll be here anyway.
Yes, sir.
Probably, in all
Yes, you
likelihood. Okay.
Your Honor, that was my biggest concern, was not to tie up your schedule, only to untie it if we go down this preferred option.
Okay. I guess we could do it one of two ways. I am inclined to, of course, grant a continuance to the February meeting. And I guess we can condition the continuance on, continuing, if you will, beyond that date, on having a complete application with all fees paid by by February 15.
The fees can't be paid until after the excuse me, Your Honor, but the fees can't be paid until after the application is submitted, and they can even determine the fee schedule.
But this is why you shouldn't wait till February 15th to file the application.
Yeah, I mean, I hate to, not that you're not going to follow
I'm not
up,
trying
but
to
I
be
hate for you to
difficult,
file an application, not pay the fees, and then we're off another month.
We're too vested in the property not to do that, Your Honor.
Well, is that how it works, though? You get the application, then somebody has to take a look at it and see how complicated it is, and then figure out what the...
We look at it, but the cost recovery normally comes along with the application, because technically it's not a completed application, not the cost recovery.
Right, well, that's why I was
How does
thinking,
he get the number for cost recovery? How does he know the number for cost
We
recovery?
will work up a number, and what we can do is I can try to have that number available to Seth by Friday.
That's just a guesstimation without having an application complete due to the complexity of the situation and the several structures that are there.
No, we can tell pretty much based upon other projects that we have processed. And when we try to be lenient or easy on the figure, we've ended up having to go, and then we're in arrears and we have problems. So we always try to do a fair estimate, but it's not going to be, I'm just going to warn you now, it's going to be expensive.
okay.
You made some comments in that regard, so I just want you to be aware of this. You could be looking probably anywhere between $5,000 and $10,000.
It's awful hard to guess off the top of your head, Mark.
Well, whatever it is, I'm assuming the town has done this before, and this is going to be what, land uses, there are going to be other approvals necessary, site plan?
Well, that's part of the review, I think, that Mr. Kilday's doing, because we're concerned also about whether maybe there's got to be some variances if there's setbacks. We don't know if any of the uses out there would be allowed, but would need either a conditional use or a special exception. You know, that it's kind of complex, and what is needed other than a land use amendment. So that's why it's really important and really critical that the sooner we can get something in them from them, so that our planner can get involved and deal directly with Kerry Kilday and figure out the scope of this application. Then we also have a better idea of how expensive it will be, one application and approval versus 3 or 4. So that was what we needed to have really all along, is that initial step and understanding of, if he wants to do this preferred route, what does that entail? And I think we're only, from the letter I got there and from what I heard this morning, we're in that stage right now, only of figuring out what it is they have to ask the town for to get what they want. And they need to resolve that very quickly so we can get something from them by was it the 15th? Yeah.
We have no problem to try and get the application complete, Your Honor, but once the application is submitted, I'd like as accurate of a fee schedule as possible. You have to, granted, there's still a moratorium in place, so our money is going to be, our application is going to be sitting dormant, and our money is going to be sitting dormant. But if we can get our application filed and then get a fee schedule and have 30 or 45 days to get that paid, then we should be right around the time that the moratorium is lifted, and our actual money will go to something that's going to be able to be worked on.
Let me clarify, it won't be a fee schedule. It'll be an estimated fee that it has to accompany the application. We try to come up with a fair estimate, but in many cases, sometimes because of unforeseen circumstances, as Attorney Cirillo has just indicated, we do have to go back and request additional monies. We keep an accounting, and once the application has gone past that amount, and in cases where we tried to estimate a little lower, we've always gotten burned. So we try to come up with a fair estimate, but one that is probably not going to put us in that situation.
So what the town tries to pass through is your land planner, your legal?
Land planner, legal, advertising, any costs that we would incur as a result of processing the application.
Engineering.
Yeah, if there's engineering required, we'll have other people look at it. It doesn't have a full-blown DRC, but there are other folks that may have to look at it.
And Jeff, are you still there?
I am.
I just want to make sure, we hadn't heard from you for a while, so I want to make sure we didn't drop you.
And if I may,
Oh, no, I'm trying to be professional and courteous.
and if I may
As always.
also add, Mr. Magistrate, I want to remind Mr. Byers that, every time we come into a meeting and the meeting is continued, that I want to remind you that there's still costs that are being incurred. And if you're not found compliant, that those costs are going to become part of an administrative fee that would also have to be paid. So it kind of behooves you to move as quickly as possible to be able to submit these, because there are costs incurred with us being here every time that
I
we
understand
continue.
that. I understand that. That's
And
why
that's
I
on the
guess.
code enforcement
That's
side.
why I guess, according to the land planner, that's why we were requesting 60 days, not to waste the town's time, not to waste your honor's time, not to waste the city attorney's time, due to the complexity of all the buildings, and to notify if we do need a variance, if a setback doesn't meet, or what it is to accomplish. Correct, Mark?
That's correct.
Well, let me remind you again, we've been working this case. By the time we come back in February for the continuance, we will have been working this case since March of last year.
Ma'am, this case stems from 2008,
Yes,
where
you've been
where in
following.
2008, I won, and this went away. However, after Frank Spence left and Mark took over, it got reopened because the same complainant, who is my direct competition, Mr. Beck Islop, who testified from Red Barn last time, he filed an additional complaint under Mark's term, okay? This should not even be a hearing, because when we did it in 2008, you can go back and check the records, we should not even be here. So this is costing me a lot of money in attorney fees to resolve this matter.
Mr. Dunn, we're kind of getting a
Yeah,
little bit
we're
off.
getting a bit off.
All we want to do is figure out if we're going to get a continuance until when, and we can argue offline.
Yeah, let me just ask one other question here. I guess from the town's perspective, what I'm thinking is that the application needs to be in, but we're not even sure what the application needs to be, I guess, at the moment. It's going to need land use, but it may need variance, may need...
That's what they need to figure out based on what they intend to do with that property. Because obviously they can keep everything the way it is, they can read things, move things around, whatever they're able to do to minimize what they need to ask of from the town. But they have to tell us what they're asking. We're not going to tell them what to ask us for.
Right, well, certainly it's their property, they need to...
Correct.
They need to be able to control what you want to do with it.
Yes, sir.
Okay. Anything else, Mr. Brown?
No, other than, again, thank you for letting me attend by telephone, and I do understand what the city is asking, and we will comply.
Okay. What I will do then is I'll continue this matter to the February 20 hearing with the proviso that the alleged violator is required to submit whatever land use applications, including payment of fees, by February 15, or the matter will, obviously, you could agree to continue it again if we get to that point. But otherwise, we would be prepared to proceed with the hearing on February 20th if everything is not received by February 15. And we don't know exactly what applications will be required because of the nature of the property, and I know Mr. Kilday is just getting started, so we can't be more precise on what has to be filed. But whatever is necessary to proceed, or at least convince I guess, the town that the applicant's moving forward in good faith by the 15th. So I'll enter an order to that effect, and if the application's not in, or if, I guess if the town does not acknowledge that the applicant has made a good faith effort by the 15th, will be on the agenda for the 20th. There's certainly the continuance application could be renewed at that time, and then depending on all the facts, I'd have to consider it at that point.
Your Honor, could I ask if the application is done by the 15th, like you're suggesting, if the fee schedule could be 30 days after that, so they can give an accurate determination based on the application that we're turning in of how much the fees are, to allow an additional 30 days for payment for that?
The town won't incur any expenses reviewing anything until it gets a deposit. And
Right.
that initial payment is a deposit, it's an estimate. If it's
Right.
over month, and it's separately accounted, it's separately documented. If the town's estimate's too low, we're gonna stop work until we get it supplemented. If the estimate's too high, then they're gonna get their money back on the difference. So, I don't know that that's really, the town would not begin to incur expenses of planners and legal unless it has some deposit. So there's gonna have to be something filed, so I would object to that condition.
Well, will you be lenient on the deposit until we can get that done?
You have to, I think you've made it clear
Yeah,
what it is.
Yeah, I think we need the
For your
deposit,
purposes.
and I would ask the town to, are you gonna be able to give an estimate on the deposit before there is an actual application?
I would intend to give an estimate by Friday.
Okay. And again, knowing, I guess, the way the process is in the town under its code, it's an estimate anyway.
That's correct.
So,
I mean, at some point, we may be changing that code to try to be more specific and more precise, but right now, that's the code we have to work with, so.
okay. Anything else? I'm sorry?
Jeff, anything
No, other than I tried.
other than what?
I understand.
Okay.
Okay.
Mr. Magistrate, you will be issuing an order to that effect.
Yeah, I will enter an order since we're going to be moving forward this way, and I'll get that out. I guess I'll get your address, Mr. Brown, someplace. They must have it here, so I'll get that so you get a copy.
So once the application
Yes.
is submitted and the check is submitted, then these hearings go away?
Well, let's talk about what we're gonna do with that, but for now, we're continuing it today.
Yeah.
And I can talk with Jeff, I can talk with you guys about that, how it works from here.
Okay.
Outside the presence of the hearing officer.
Yeah,
And it just be focused on
If
the case.
it's continued, I think my thought would be then, and you've applied, I think the process then needs to work itself out. If for some reason you don't diligently proceed with your application, I could see the town maybe wanting to come back in.
But there's still a moratorium with that.
Well, assuming you get the continuance, nothing's going to happen really by, March anyway, or April.
Thank you.
It's going to take that much time.
I would think,
Seth, if you save your questions for me, you can let these people go.
All right, thank you.
Okay, I will enter an order to the effect of what I've just discussed, and anything else we need to address this morning? That's it, okay. It is 10:22, we will adjourn.
thank you.
Thank
Jeff.
you.
Thank you.
Thanks, everybody, over now.
Thank you, Jeff.
Thank you.
Thanks, Jeff.
Bye.
Having deja vu with this camera. Didn't I just do this
No,
8 hours ago?
I know. Pretty soon we're gonna be like sleeping here, everything else.
Murphy beds in the office.
Yeah.
Down here, I see it. No, It's in this extension here.
Yeah, it's all in the extension. Oh, wait a minute, I gotta see this. Don't do it.
Oh no, this is the camera.
You said if there's additional fees,
I
then
see.
I'll be required to.
I agree.
See you, Mike.
See you later. Give you the best guess as to what we.
I'm glad you sent me the, yesterday you sent me the, Marcella.
Yeah.
So I could say I had them.
Yeah.
That was good.
Yeah.
I appreciate that.
Yeah, so there
Well, I
will
want
be
you to
changes.
overguess.
But if we under, no, but if we under,
Then I have to
then I get to pay more.
Notice
So,
of
all right,
violation.
no problem.
Yeah, all right.
So that's how it works. Now, what I was cautioning you.
Thank you, Mike.
Fine, take care. What we got?
Two new and
One.
Oh, I know.
every time you do, there's something you forget.
That's why we need a dedicated room where this stuff can stay.
There's stuff that goes wrong every time. It's like,
Lawsuit going on.
you just can't do that.
Right.
Rush to set everything up and then rush to.
No, I agree.
So whatever happens, happens.
I don't want to jinx it.
So that's an example, so,
Okay.
Don't worry
All right,
about
thank you.
it.
But I'm gonna, I'm coming in for a meeting today on another
Okay.
matter. I'm gonna
Bye,
talk to
Mr.
them, go over.
Dooney.
Shouldn't be that complex
Yeah.
if you just carved 10 acres out.
I'm looking at a small scale, and how a small scale is take care of it.
Thank you, Your Honor.
How a small scale is handled.
Yeah.
You might have a little more
So
complexity.
if you go
I
back to
think
the
we're
red
absolutely crazy.
What's that?
I just think we're absolutely
Yeah, right?
because he does this for a lot of people and municipalities.
Oh, yeah.
I worked with his brother. His brother was a town manager in Palm Beach for 20 years.
Huh.
And then he retired, he got MS, his brother. My sister does.
Really? Wow.
Yeah, she has MS, she's a year older than
Oh,
I
this
am.
one did it.
Probably here, I'll just put it around here. Yeah, she's a year older than I am. What's this? It's not off?
You saw me out there, I guess.
I need a copy of Seth's letter too for the
Okay,
record.
Mark has a copy. I'll run off some of
Make
these
sure
back.
I get